Good morning, my magnificent young entrepreneurs. Are you ready to learn some law and make some money? Okay, today we're going to talk about employment discrimination and sexual harassment. And where we start is with Title VII of the United States Code, the Civil Rights Act of 1964. And you got to remember that this strikes me a different way than it strikes you. It's deeply moving if you've lived through what I've lived through. I was born in 1949, and so when I was a little boy home watching the evening news, we saw the race riots in the South. We saw the Alabama Highway Patrol sicking their German Shepherd police dogs on the demonstrators who were demonstrating for racial equality. We saw the Alabama Highway Patrol knocking demonstrators off their feet with fire hoses. We saw the governor of Alabama, George Wallace, stand in the schoolhouse doorway and say, "No Negro child shall ever pass through these doors." And they had to call out the National Guard to prevent the rioting so that two little black girls could go to school at a integrated school. All of those things I saw during my lifetime as a boy. And as a boy, if you had asked me if I would live long enough to see the first African American president of the United States, I would have said no way. But here we've come a long way. We've had our first African American president of the United States. I did not agree with all of his politics, but I gotta tell you, when that man was elected, I was so damn proud of our country for having done that. And then I was in fear for his whole 2 terms that some wacko might try to assassinate him. And he was not assassinated, and he served 2 full terms. And again, I was so damn proud of my country. So we have come a long way. But unfortunately, today's not a good day to talk about how far we've come, because the race protest riots are going on right now from the shooting, or not the shooting, but the police killing of this man named George Floyd. So we still have a long way to go. But in 1964, Congress passed the Civil Rights Act, and it said there shall be no discrimination in employment on the basis of race, color, national origin, religion, or gender. So at that time, that was a very avant-garde thing for them to do, and their lives and their careers were at risk. They were sticking their necks way out just to do that. But when you look at the Title VII Civil Rights Act of 1964 now, you see that it actually did not include a number of people that we now feel, or at least argue, that should be protected. It applied only to larger businesses that had 15 or more employees, and of course, because it was a federal law, it could only be applied to businesses that impacted interstate commerce. That is, businesses whose business crosses state lines. Because remember, the federal government does not have authority to regulate business unless it impacts interstate commerce. So 64, this was a very avant-garde thing that they did. And at the same time, they created the Equal Employment Opportunity Commission, the EEOC. And the EEOC monitors compliance with Title VII. And because of that, if you do have an employment discrimination complaint and you want to take it to court, you must first file your complaint with the EEOC and let them review it first. If you don't take your complaint to the EEOC first, then the court will kick it out and say, come back after you've had it reviewed by the EEOC. The EEOC will review your complaint, and if it is a problem that might make new law, it might be a landmark decision, then they will take your case and they will prosecute it for you. But if it's just a run-of-the-mill employment discrimination case, it's not going to make any new law or landmark decision, then they will release the complaint back to you, and they will say, well, you may or may not have a case, but you can go ahead and take it to court on your own now, because we do not have sufficient staff to prosecute all of these cases. We only take the really important ones. But remember, you must, if you have a complaint for employment discrimination, you must first take it to the EEOC before you take it to court. Looking at some of the things that were, the original act in 1964 covers race, color, national origin, religion, and gender. But notice that it does not cover several things that we cover nowadays. It doesn't cover pregnancy. It doesn't cover age discrimination. That didn't come along until, where's my notes here? Age discrimination didn't come along until 1967. Disabilities discrimination, the Americans with Disabilities Act, the ADA, didn't come along until 1990. And homosexuality, sexual preference, that is such a hot button issue that although we have state laws and we have some federal laws that give some degree of protection in that area, I am sure that people who have sexual preference issues would argue that we still do not have an adequate federal law that prohibits discrimination based upon sexual preference. So these are things that are not covered in the original Title VII Act. Discrimination with regard to the EEOC can be disparate treatment discrimination, or it can be disparate impact discrimination. Disparate treatment discrimination is intentional. So I have a company, and if I were Mormon, which I'm not, but if I was, I would say, well, I only trust other Mormon people, and so I'm only going to hire Mormon people to work in my company. So you come to my company and you ask for a job, and I say, well, what religion are you? And you say, well, I'm Catholic. And I say, well, sorry, I can't hire you. I only hire Mormons. That is an intentional discrimination and would be a violation under EEOC, clearly, under Title VII. The EEOC would enforce it. But it can be unintentional. Suppose I own a computer software design company, and I'm more like who I really am, which is I grew up on a military base, and I grew up next door to people of all colors and religions and races, and so discrimination is not intentionally woven into me. Everybody has a certain degree of it one way or another, but I'm really, as people go, I'm probably not very racially biased at all. And so my intention is to hire people at my company from all races and religions and ethnic backgrounds. I don't have any particular bad feelings about that. But I am in a very competitive industry, a software design industry. I must have, in order to remain competitive, I must have the best possible computer software designers. So when you ask for a job at my company, I don't ask what race or religion you are, but you have to take a test. And the test is to test the degree of your skill as a computer programmer. And if you do well on that test, I hire you, and if you don't, I don't. So everything's going along fine, and I have my company for 5 or 10 years, and one morning I pull into the parking lot early, as the boss always does, but I get hung up on the phone talking to somebody, and I'm sitting in the parking lot on my cell phone talking to somebody, and time goes by, and I am sitting there as all the other employees arrive and go into the building for work, and I notice something as I'm sitting there talking on the phone. Oh my gosh, all the people that are getting out of their cars and going into my company to go to work are waspy looking people, white Anglo-Saxon Protestants. How the heck did that happen? I never intended that. Well, it turned out sometimes that the test that you give was weeding out the minority people. You're looking for only the best possible, the most highly skilled and highly trained computer software designers. Well, maybe people that grew up in minority neighborhoods, going to schools that were mostly minority schools and low income, maybe they didn't have access to computers, or maybe they didn't have very good computer teachers, or maybe they had no computer teachers at their schools. And so it turns out that your test, although it's not intended to be racially biased in any way, it tends to weed out minorities. And that is an unintentional form of discrimination called disparate impact rather than disparate treatment, which is intentional. Disparate impact discrimination. If the EEOC finds out that your test may be discriminating, they will give your test to an equal number of black and white or minority people and white people. And if your test, if the minorities don't do, at least 80% of the minorities who take the test don't do as well as the white people, then the EEOC will say your test is discriminatory. It creates a discriminatory result, and so you must change your test so that you end up hiring more minorities. Well, at this point in time, some of you that are familiar with the ownership of business may be saying, whoa, that's totally unfair. You're telling me in an industry where I have to have the best possible computer programmers in order to remain competitive in the industry, you're telling me that the government's going to come in and tell me that I've got to dumb down my test so that I get more minorities hired in here, but I'm going to end up not having as good of programmers, and my business will be in danger from competitors. Well, you know what? Yeah, that test, the EEOC ruling that you've got to change your test might end up dumbing down your test, and you might end up getting a little bit not quite as highly skilled programmers as you want. So there might be a little unfairness in that. So how do I respond to that? Well, I don't have a really good response. Well, maybe I do. I have one response for you, and it comes from a former Chief Justice of the U.S. Supreme Court by the name of Earl Warren. And Earl Warren was there on the Supreme Court when they passed the Brown Act, which was the first act that said no more segregation of the schools. Schools, black and white, have to be integrated. And the arguments against integration at the time of the schools was separate but equal. As long as we provide teachers and schools that are just as good for the black kids as the ones for the white kids, separate but equal is okay. And the Supreme Court said, no, separate but equal is not okay. First of all, you know dang well that the schools and the quality of the teachers in the black neighborhoods are not anywhere nearly as good as the schools and the teachers in the white neighborhoods. So it's not separate but equal. But secondly, even if the schools were equal, separate would still not be equal, because kids in schools form lifelong friendships and acquaintances and alliances, and when they grow up, those friendships and alliances and acquaintances become business friendships, acquaintances, and alliances, and business opportunities. And if you're separating all the black kids from successful upper middle class white kids, what you're doing is you're depriving them from a little hummingbird just went by my head. Did you see that? It's kind of cool. You're depriving those black kids from, it's not separate and equal. So they said, from now on, you're going to integrate the schools, even if you have to bus kids across town to have a racial mix in every school. Well, at the time, excuse me, at that time, when integration was forced in the schools, there were white middle-class people that cried foul and unfair and said, look, I worked my tail off for years so that I could make a little extra money, so that I could buy a nice house in a nice neighborhood with good schools for my kids. I paid extra money to have this house in a nice neighborhood with good schools, and now you're telling me they may have to bus my son all the way across and go to school in a ghetto, and they're going to bring kids, black kids from the ghetto, and bus them into my school here in this neighborhood. That's unfair. It's just totally unfair. And they said this to Earl Warren, and he said, yeah, you know, There may be a little temporary unfairness in this, but sometimes society has to bear a little bit of temporary unfairness in order to correct a much greater unfairness and injustice that's been going on for a lot longer.